음, OK，这个词
Any mentioning? My lordship, item number 17.
17.
This matter may be taken up today.
Why are you mentioning today and saying that it should be taken up today? Why? What were you doing all this while?
Yesterday, Mrs. Nandini Sen,
Yes, your lordships, we have been waiting very patiently for quite a number of days, your lordships, and it often so happens that like the other day it was placed as item number 18, then it went down to 30, and then 22nd. Very patiently we have been waiting. So anytime that is convenient to your lordships, of course, I cannot force further.
Mute. What is the urgency in item number 17?
Urgency is, your lordships, the petitioner's service has been terminated, and not only that, the challenge was with respect to an order passed by the learned Central Administrative Tribunal, stating that declaring that the subsequently that particular termination, or after that, he's challenging the order passed by
That is the date of the
learned where the subsequent list has been published without.
You don't know. You're not even ready. How can we take up the matter? What is the date of the reviewed order? Miss Sen, you don't even know the facts, and you want the matter to be taken up on an urgent basis. We can't hear you. We can't hear you. Unmute yourself, please. দেখো দেখো কি হচ্ছে, দেখো শোনা যাচ্ছে না। Yes, what is the date of the order?
21 to 2023, your lordships.
21 to 2023. We are going to complete an anniversary soon. Why have you not taken any steps?
Your lordships, number of times the matter had come before this honorable court. There were then time had been taken by the respondents also, saying that they were not served and all. Then subsequent service has been, a number of orders have been passed, but this was not been taken up for hearing, your lordships. That is the problem. So therefore, with
1 year has passed. 1 year. When did you file the writ petition?
We filed in time, your lordships.
Then
we filed it on the date of file. I'll just get it, your lordships. We filed it on 13/6/2023.
And so many circuit benches have gone, and now you're saying on the last day that you want this matter to be taken up. Sorry.
No, your lordships. Probably I have not been able to express because probably mute and unmute problem. Your lordships, certain honorable circuit benches had taken up during the notice. It was declared that it will be heard, matter would be heard, and subsequently, your lordships, the respondents, sometimes were not present. Sometimes they said that they were not. The instruction was not available with them. Like that, quite a number of orders had been passed. Now, in the
mute. সোমবার দিন একটু ম্যাটারে তুলে দাও, তবে we'll see. Yes, any other mentioning? Any other mentioning? Yes, call on the list, please.
Item number 1. In this act of the petitioner, my lord, is an application for bail under section 439. I was arrested on 5th of December 2023. The narcotic.
Let my learned get the papers. Yes. Yes.
On 28/11/2023, the narcotic unit got credible information, my lord, that was 5/12/2023.
Yes.
On 28/11/2023, the narcotic unit got credible information that one of the accused, Salim Barla, is in possession of contraband methamphetamine. Raid was conducted, my lord, and 32 grams of methamphetamine was seized from Salim Barla.
Yes.
Upon sustained interrogation of the said accused, he revealed my name, the name of the present petitioner accused herein.
Yes.
And the allegation against this present petitioner accused is that he has transacted certain money to the account of the prime accused. That is a sum of rupees.
So Salim Barla is the prime accused?
My lord, no recovery was made from my possession.
Anything else, Mr. Govind?
And my lord, the charge sheet was filed on the 60th day. This is an intermediate quantity.
60th day.
My lord.
It's intermediate quantity.
My lord.
22 grams.
32 grams, my lord. And the other
50 is the commercial.
50 is the commercial, above 50 and 50. And the accused Salim Barla, he was released on bail by this honorable court, my lord.
Salim Bhalla released.
My lord.
Show us. Yes, Ms. Zinu.
Yes, Your Lordship, certain financial transactions are there. Rest all submissions, my learned brother has advanced, financial transaction was established, and section 29 is attracted.
Yes. The undisputed case is that no recovery of narcotic substance was made from the petitioner. Stop. We are also informed that the prime accused was released on bail on 7th February 2024. Stop. The name of the petitioner also transpired from a statement made by the prime accused. Stop. Next, it is more relevant to state that the quantity recovered from the co-accused, don't say prime accused, co-accused, all co-accused. Co-accused is of intermediate quantity. Stop. Next, we are hence of the opinion that the petitioner is entitled to bail. Stop. Give that paragraph, please. 10,000. CRM NDPS 3 of 20. CRM NDPS 4 of 2024 is accordingly allowed and disposed of in terms of the above.
Obliged, my lord.
That's fine with the base.
Yes, yes. That line, please add.
Item number 2, CRM NDPS 5 of 2024.
So much of quantity, few sets have already come before this honorable court. Few sets of accused, there are 11 accused persons in this case.
Yes.
Few sets of accused person came before this honorable court, and this honorable court has rejected their bail application and directed the trial court to finish the trial within 4 months.
Show us the orders, please.
This is that particular.
Trial commenced and 23 witnesses already examined.
No, 20.
10, no, 23 have confirmed, and 10 is more left. And today also the date is fixed.
For hearing of an application, not for witness.
Where is the second page? Which affidavit? Where is the second page of the order?
ये भी एक है, आप कौन वाला
Only
दिए?
2 pages.
तो विजय जी था,
Only 2 pages.
कौन वाला? नदीम वाला दिए?
हाँ।
नदीम,
हाँ।
ये अमृता मलाकारी है, दूसरा वाला।
Yes.
नहीं, ये
दो।
सर्वर कॉपी मिला तुम।
Yes, you're part of the same group.
Yes, same group.
Lordship, my case is otherwise, let me make my submission.
Yes.
Lordship, this particular, I want to narrate the facts so that your honor.
No, do it quickly, please. You have to rise early today. Yes.
Yes. Lordship, the page number, yeah, Lordship, in charge sheet, page number 8, like, charge sheet, man.
Page number 8.
8 of my charge sheet, this is the application, Lordship.
Where is the charge sheet?
Charge,
Page 8.
page 8, man.
Yes.
Lordship, this particular petitioner hearing, there is no recovery from his possession or not even a financial transaction or any bank statement has been recovering from him. But what the prosecution is on the fact that on 7/7/23, a suspect named Manikandan so-and-so has interrogated lengthily on who disclosed
Reading from?
yeah, page number 8 and paragraph 4
Yes.
on 7/7.
Yes.
On 7/7, the suspect named Manikandan, so-and-so has interrogated month, so disclosed on 26/23, he mediated to procure 500 grams of methamphetamine with the assistance of one Jinku Malik, so-and-so, and and to one Nagni. After running, so they have also been interrogated who accepted the guilt. The accused Nagin disclosed that he has given the said contraband article to one Abdul Imran. The one Abdul Imran, particularly this was the allegation against me that I was the mediator to procure 500 grams of methamphetamine to one Jilku Malik. From Jilku Malik, it has went to Nadim. Nadim from it has been Abdul Imran. If you honor sees all these two accused, Jilku and Nadim, there is no recovery. There is no financial transaction between us or anything. From Abdul
So Nadeem was not given bail, was not
given bail.
Yes.
This was not given bail. But there is from Abdul Imran, there is a recovery of 28 grams, which is the intermediate quantity.
No, but this is commercial quantity, 500 grams.
We have an allegation against me, but in the seizure, even in my, if you honor see, in my bail application, I annexed all the witnesses who have deposed before this court. Not even a single witness, even from the complainant till 17 witnesses which have got the separate copy, not even a single witness stated my name on any of, even the chief, they have not stated anything.
Manikandan paid 2 lakh
One
rupees.
minute, Miss Zinu, we will come to you. Yes.
Yes. There is, if you honor see all the charge sheeted witnesses, including the private witnesses, right now they left only 10 witnesses plus 6 more witnesses they want to examine. So for that particular, this matter is fixed today in the trial court below for hearing of 311 application ownership. Regarding the rest of the charge sheeting witness, altogether are 33. 23 are examined, rest witness are official witness. The police persons
23 out of 33 already examined.
examine. All 23 witnesses, my lordship, no one has stated anything about the particular person who is.
And 23 witnesses have been completed in what time?
Day-to-day trial has been fixed immediately after. Day order.
20 of
Today also it is fixed.
No, when did the trial start? 20
20 December.
1 minute.
Yes.
20 witnesses finished in how much time?
Within a 1 month.
1 month. You wait.
Lordship,
No,
there is a
no.
difficulty because my financial condition,
No.
I have four
2 witnesses in 1 month is very good progress. You wait 10 more witnesses, you wait for that.
Lordship, they want to examine further more witnesses. They want to file a supplementary charge sheet.
No, we will give you that option to come to the court. If there is delay on the part of the trial court to finish the evidence of the rest 10 witnesses, or if they go on bringing filing supplementary charge sheets and saying that we want to examine more witnesses, we will give you that option to come to the court.
Lordship, the thing is, I have a 4-year-old boy. Right.
These considerations, everyone has some difficulty or the other.
Only official witnesses had to be examined, Lordship. Entire private witness has been examined.
Yes, and when did the examination start? From from when?
Just a minute. Just a minute. The trial started
On 20 December, no.
20th December, you're saying 1 month? is
20
the-
December
No.
is the first
I was-
examination. You wanna come to my bail application, page number. There is a chief I have.
I have the
Chief is-
entire charge.
Yes, yes.
Taking
Tell us,
it,
please.
I'll just-
Correct.
I'll just,
Lordship, page number 52. Lordship.
yes, 20th of December, it started, your lordship.
Hmm.
And continuously, it is going on. Meanwhile, they went for some modification and all. So, anyway,
Very well. So 20 witnesses finished in about 1.5
three
months.
witnesses we finished,
23 witnesses and 10 more.
10 more.
Very well. The allegation against the petitioner is under the provisions of the NDPS Act, 1985. Stop. The petitioner is alleged to be part of a group of individuals, two of whose bail applications were rejected by a coordinate bench on 12th December, on 11th and 12th December 2023. Stop. Next, although Common Learned Counsel appearing for the petitioner submits that there was no recovery need from the petitioner, and the petitioner's name transcribed from a statement of a co-accused, comma, we note that the learned trial court has completed the evidence of 23 witnesses from which date did you say in December?
20th of December.
From 20th December 2023, and only 10 more witnesses are left. Stop. Considering the progress, next, considering the progress, the rate of progress in the trial, comma, we expect the trial to be completed very near in the future. Stop. If the petitioner, if the trial takes, if there is any delay in the trial, or if the prosecution proposes to bring in more witnesses after the 33, which are already to be examined, the petitioner shall have the option of approaching the court for appropriate relief. Stop. Next, CRM NDPS 5 of 2024 is accordingly rejected in terms of the assault.
Oblige.
Item number 3. Here I am NDPS 6 of
Just, Stephen, just one line, please. We consider it appropriate to request the learned trial court to dispose of the trial as directed by the coordinate bench in its orders of 11th and 12th December 2023. Stop.
Item 3. Here I am NDPS 6 of 2024.
Lordship, I am appealing for the petitioner.
I pay for the statement. No?
This is the case of official secret, the one of the,
Sorry,
is a case of official secret, where the one of the
it's official secret. It's
official
official
secret
secret.
acts.
Yes.
The one of the co-accused have got a bail from the Hon'ble court. Your Honor has passed this particular order. My case is
No, that was to do with the naval shipyard
yeah.
or something.
same case, Your Honor. I am the co-accused in this particular case.
Yes, Mr. Mohammed, who is this Shuntu
I am the Abhishek Kumar Gupta, the petitioner. The Santu Biswas was got bail from this honorable.
was the one who had that liaison with that lady.
I'm the petitioner. I'm the
Main principal accused.
Yes, yes. He's the one who had some sort of a liaison with the honey trap,
honey-
with the lady.
yes, yeah.
You can't be in the same footing with Shuntu Bishop. Shuntu Bishop was the ordinary seaman or whatever that post he was occupying.
Even I'm on this same post, my lordship. At the time of FAR,
There are monetary transactions.
lordship, they,
Check Gupta and that lady
lordship,
and the Instagram chats.
lordship, I can show that. I have already filed the charge sheet, lordship. If I can show the chat also, if
Yes, we remember the chat.
the chat,
Yes.
if lordship, the thing is, I'm the 19-year-old boy, lordship. I'm 19 years, just 19 year. My
If you make all these submissions of 4-year-old child and 19 years, we will dismiss it at the outset. Criminal trial is not about that.
lordship,
19-year-old and all that. Yes.
my contention, this particular, if you honest, come to the page 11 of the charge sheet.
No, এটা হচ্ছে নেগোশিয়েশন আছে। এখানে বিভিন্ন তার সঙ্গে একটা নাম ছিল তার সঙ্গে ইনস্টাগ্রাম চ্যাট ছিল তারপরে ছিল।
At the time of FAR, I was not in this island. During on the month of September, I was a contract guy.
No, we are not inclined to we remember the facts of the other case.
Because
Yes,
your
yes, Mr. Mohammed.
particular Aarti Sharma.
He is the principal accused. And
We remember the facts, yes,
already know the facts about this case.
yes.
This is extrajudicial confession. Oral.
No, that under 161,
No. Extrajudicial confession before the
164.
security. Extrajudicial confession. The accused, he confessed during the course of interview by the naval authority. He confessed certain facts. And that amounts to extrajudicial
Confess to
confession.
who, Mr. Mohammed?
My-
Confess to who?
He confessed before the naval authority.
Naval.
Is a record,
Yes,
is a record.
show us the record, please.
my lord. He admitted certain facts before the authority, and that amounts to confession, extrajudicial confession. And what is the veracity of that confession, the trial court will see.
This is 161, Mr. Mohammed.
My lord, is a written record.
Can't you understand that question?
My lord.
It is under 161 of the CRPC. What is the weight of this kind of evidence?
My lord, during the course of, it is before.
Why is he naval superintendent it's before the police?
My lord, they were employed in the naval authority, with the naval.
Mohammed, you are absolutely, you just don't come prepared.
My lord,
Every matter,
my lord, just,
you are never ready in your matters.
my lord,
Yes,
I beg pardon.
yes, as a public prosecutor, you should be ready with the facts. And why you saying naval officer, it's before the police? 161, 164, you should be telling us the difference.
My lord, they have furnished the information to the police.
Yes,
That is my lord.
we are not inclined to grant the application for bail. Stop. Our view is on the particular facts of the matter and on consideration, and particularly on the consideration of the fact that the petitioner is the prime accused in the offence charged against a charge under the Official Secrets Act, just check the year, please. What, 1962 or something, just check it. Stop. The fact that we have granted bail to a co-accused in CRA BB of 2024 is cannot be a ground for relief, since the petitioner since the appellant in that case was on a totally different footing. Stop. Next, you have been in custody since when?
From 6/10/2023.
Next, we have a request from the trial court to expedite the trial of the case as far as is possible for the court, for the learned court. Stop. CRM 6, CRM NDPS. This is NDPS.
No, Lord.
No, it is wrongly,
It's says NDPS.
wrongly recorded, my lord.
CRM. We are informed that the presentation form, that the matter has been wrongly recorded in the presentation form, since the matter does not involve the provisions of the NDPS Act. Stop next CRM. So it should be what, BB6? CRM BB6 of 2021. It's 2021. That is also you have not corrected.
Lordship, there is.
It says 2021 in the presentation form. The presentation form has other mistakes. Stop next. CRM BB number 6 of 2024 is accordingly rejected in terms of the above. Yes?
Matched with the actual CRN DB6, which was numbered as, this will have to be renumbered now. Otherwise, that application.
Yes, that's right. That's right. Yes, the department is directed, since we cannot give any number to the application. No, since giving any number to the application may result in a clash with next CRM, the application made by Shri Abhishek Kumar Gupta in relation to GR case number 960 of 2023 and FIR number 80 of 2023 dated 3/10/2023. PS CCS US under section 359 of the Official Secrets Act is accordingly rejected for what other reasons.
Like,
Grateful, my lord.
Item 4, CRM NDPS setting up containing four.
Sorry, we can't hear you. Yes, yes.
Lordship, I am for the petitioner. It is a case of intermediate quantity, Lordship. The quantity is 7 kilo, Lordship. The intermediate quantity ganja is from 1 kilo to 20 kilo.
So we can't understand the intermediate quantity.
Yes, Lordship. Yes, Lordship. 7.2 kilo. Intermediate quantity of ganja is from 1 kilo to 20 kilo, Lordship.
Found to be in possession from the accused person when he was inside an hotel. In hotel room, he was there with the ganja.
Lordship, the facts of the case is that one of the accused, Animus Reservoir, who has brought the illicit ganja from flight, and he has come to my room to transport the same to the island. Because I being the vegetable seller, I used to come from Delhipur, sell here, stay in here for 2 days, sell the vegetables and go back. On that, when we came to give the parcel, the police investigation team came at the hotel and they had
Yes, Ms. Zee, what
Okay.
do you have to say?
I have to say, Your Lordship, they were found to be in conscious possession. Both of them were staying in
Intermediate
same-
quantity.
but intermediate quantity, which I cannot deny.
Yes, yes. Considering the fact that intermediate quantity was recovered from the petitioner, we are inclined to grant the application for bail. Stop. Our reason, the ground for giving relief is also under section 22B. Is it 22B?
22B,
29,
29, 27,
Yes, 22B, 20 circle.
20B. 20B, 27 and 29.
20B or 22B? 20B.
20B, subclause B, capital B as well, 27A and 20B.
No, that is you're talking about the charges
Yeah.
for giving relief.
Right. Acha, for
Yes, just reframe the sentence, please. Just delete it. Admittedly, comma. And recover from the petitioner.
yes, recover.
Yes, admittedly, comma. The contraband substance allegedly recovered from the petitioner was less than commercial quantity. Stop. We accordingly allow the prayer for bail. Stop. Just then give that 10,000. CRM DD 7 2024 is allowed in terms of, allowed and disposed of in terms of the above.
Obliged, Your Worship.
Problem.
Item number 5.
লিস্টে চলে গেল বোধহয়। মানে সিম্বল ওনার লিস্টে তো ওই আগের কোটেশন চলে গেছে। ওটা তোমার বাদ দেওয়া আছে। তুমি তো ইয়ে हो ना, তুমি तो तीन और कुछ एग्जाम हो ना, क्या करेंगे? वही करेंगे। अच्छा तो ये यार तो শোনো, যেটা মহিলা মেনশন করছিলেন না, ওটা সোমবার দিন একটু বিস্তার করে দিবেন।
My lord, slight revisions before the
Yes,
case starts.
microphone please. Yes.
My submission is that the writ petition is incomplete.
Incomplete.
Incomplete, my lord.
Incomplete as in incomplete served on you.
Certain documents have not been filed.
Which, what document?
And just.
Yes.
Kindly come to page. That the minutes of the meeting, my lord,
Page number?
page number 204.
Hmm.
204, 205. The
204.
205.
Hmm.
The third page is missing. There is-
206.
There ought to be another page.
206 नहीं है आपके पास।
नहीं,
What, right?
456 नहीं. Next,
So just a minute. Your lordship has that 206. 1 minute. Yes, because if the problem is no, we have 206. Yes, I will supply.
it is not there.
I'll give you.
Another point, my lord.
Yes, I will give the correct thing.
My-
Yes, just mention it.
Another, that this is 204 is annexure which is mentioned at para 3H of the application at 146. Thereafter, two annexures are there.
3H 146.
147, my lord. 146, there are two annexures after 5. This is the minutes of the meeting. Next page is my next annexures, two annexures are there, annexures 6 and 7.
Yes.
That is at 147, page 147 and 148. Those annexures are not there.
Those are your documents.
It's not, my lord.
It's all the parts
That's
of the
right, my
reply.
lord. But that's my.
Those are your documents.
Of course,
They're
certainly.
both the documents. Yes.
These are my documents, my lord, but it is not there. I had yesterday night.
Yes, Mrs. Nag, copy, give him copies right now. We will hear the matter.
More.
Yes.
Just that's not there. Well, the paragraphs are totally mismatching. The documents placed on record and the arguments are mismatching totally.
Doesn't matter. We will hear the matter. Yes, please serve the copies right now. Please. I think we have.
Six, ये ठीक है देखेंगे.
I'm ready with the copy. Yes, yes.
Yes.
Copy everything. Is there.
My lord,
Yes, you serve it right now. We will hear the matter.
Mr. Wilkut. First of all, then.
And ask your department to give you copies anyway. Those are your documents.
My lord.
Yes.
My lord, kindly have a look.
Yes.
The documents there are 6 petitioners in this application,
6 petitioners.
my lord,
Yes.
1 to 6. Petitioner number 1 is Deepak Mistry.
Yes.
With regard to his documents, the governments are at page 5, para Roman 1, 2.
Yes.
These are these documents and petition number 2 is Nageshwar Rao. Petition number 2 is Nageshwar Rao, my lord.
Yes.
Nageshwar Rao, his documents is annexure 5 at page 6, my lord. At page 6.
Yes.
His documents are 5, annexure P5, P6, and P7.
Yes.
But all these documents do not belong to petition number 2.
Yes. What is it, Mrs. Nag? No, Your Lordship.
Kindly, just. Kindly.
Mr. Lal, you will hear the matter.
My lord,
All right.
my
You will
lord,
hear the
my
matter.
lord, this petition was totally a riddle, more than a riddle.
You will get your chance. Yes, Mrs. Nag. You will get your chance. Yes.
My lord, all the documents are not matching, my lord.
Mr. Lal, we will impose costs. That is what we do in the principal bench when counsel makes submission. That is what I do in my court. When any submission is made to take a matter out of my court.
This is not, this is not.
You will.
Certainly not, my lord. Certainly not.
You will get your chance.
My lord, thank
To make your submissions, sustaining the order of 10, we will hear you.
you.
But don't say these
My
things,
lord, my
please.
lord,
Yes.
my lord.
Case is that, Your Lordship, these petitioners, they are working in the feeder post, that is fitter. Now, Your Lordship, the promotional post is chargeman.
Promotional post?
Chargeman. Case is that they wanted ACP, Assured Career Progression Scheme, the benefits of that.
Please address my
Yes,
learned colleague.
Your Lordship, they wanted the ACP benefits for the post of chargeman, because so far as ACP and MSCP, the difference is that ACP is granted for the promotional post, MSCP next grade. Now, they wanted that the post of chargeman, that scale they wanted for ACP, and they are agreeing also. But the scale which has been mentioned by the authority was incorrect. Some persons have approached this honorable court, and this honorable court has said, yes, that scale is not correct. It should be in accordance with the pay commission, and the scale of pay was granted to them. For the post of chargeman, scale was revised. We have approached the authorities that as the pay scale of chargeman has been revised, so ACP benefit we should also get in the same revised pay scale. Then they did not do it. They have said that in terms of the report of the 5th Pay Commission, it can't be granted to you because it is available only for diploma and degree holder of engineering cadre. These people are a subordinate cadre of engineering, this thing. So unless and until you have diploma or degree, you can't be granted with that.
Unless that qualification possesses those qualifications.
Yes, the petitioner should possess that qualification. Then only you will be granted that. No, Your Lordship, my case is that the government of India initially decided, because 5th Pay Commission, all commissions are recommendation. Now, government of India has decided that there should not be any difference between diploma, degree, and all those things. All should be granted the same thing. So, in the same department, the junior engineer,
That's the 5th Pay Commission.
yes, 5th Pay Commission recommendation was subsequently accepted by the government of India in the manner that there should not be any difference between diploma, non-diploma, and all should be treated alike. So in the same department, the junior engineer who are non-diploma holders, they are getting the ACP benefit for the post of chargeman in the scale of chargeman. That is the revised scale on the basis of the government of India's decision. This was my case before the tribunal, that when they are getting, why we should not get it, when we are also under the same subordinate engineering cadre. but the tribunal did not look into that aspect at all.
Seven applicants.
Yes, Your Lordship.
Yes.
Uh,
Yeah, sorry, please continue.
yes, Your Lordship. So
So I was looking at your, we were looking at your praise.
this was my case, and just a minute, Your Lordship, I'll just refer to that.
227.
And I have given the instances also along with my rejoinder that how those persons have been given the scale, a higher scale of chargement when they are also holding the diploma or degree in engineering. So those examples also I have given from page number 219 to there are a number of pages
You
here.
have been granted the great pay of 2,800
Yes,
and your claim is 4,200.
yes, that is the actual revised scale of chargement. But there can,
And where is the order of the authority dated 17th of May?
17 May 2019.
Your Lordship, I'm
You
sorry.
wanted portion of that.
Page number 126. My entire case is based upon page number 209.
209 is your representation.
No, Your Lordship, the Government of India's order. 209, may I place, Your Lordship? I am directed to refer,
According to you, this order dated 17th of May 2019 did not take into consideration page 206.
yes, 209.
209.
209.
Neither that order nor the order of the tribunal. Because that is my case. Even I know the 50 commission recommendation was only to the extent of diploma and non-diploma. And all commissions are the decisions of the commission are only recommendation. Unless and until the government accepts it, it will remain as a recommendation only. So the acceptance which has been done subsequently, it is in this manner, page number 209.
What is the date? 21st August
2008.
2008.
Yes. I am directed to refer to administration letter number this dated this in that, and to say that the proposal of the administration regarding upgradation of scale of pay of non-diploma holder junior engineers in the electricity department from this to this has been considered in this ministry. In consultation with the Ministry of Finance, it has been decided to grant the upgraded this to non-diploma junior engineers of the electricity department with effect from this. This issues with the approval of the Ministry of Finance. So the higher pay scale has been granted to junior engineers.
This says rupees 5,000 to 800, to 8,000.
That is the pay scale, Your Lordship.
Yes.
Because subsequently after the,
You have asked for a lesser amount.
that is great pay.
Great.
Great pay. Great pay is 2,800. I am getting it. I should get 4,200 because now the pay scale is changed to PV band. Yes, great pay.
You are in which department?
Electricity.
You are also in electricity.
Same electricity department, non-diploma junior engineer, they are getting that particular grade pay, but we are not getting it. Only on the ground that we are not holding the diploma or degree in engineering.
What is the reason given by the tribunal for rejecting your application?
The commission recommendation. This has not been looked into at all.
No, page 209 was placed before the tribunal.
Yes, Your Lordship.
Show us that.
Annexure along with my original
No,
application.
show us that in the course of hearing, you referred to this and we placed reliance upon this.
Your Lordship,
And what is the decision of the tribunal?
we have argued the matter.
This is not a difficult case.
Application.
Did the tribunal record that in the order that you have pressed that or you have,
It is never done.
then Mrs. Nand,
No, Your Lordship, it is never done. I
then the
can cite number.
it is otherwise. You have to approach the tribunal with a prayer for review. That is the,
Your Lordship,
civil law.
what
Whether
argument?
you have pressed Mrs. Nand,
Just a
that's the
minute, Your
question.
Lordship. What we are arguing, that is many a times, Your Lordship, that is not recorded. But I have argued the matter in that line, Your Lordship, that can be reflected from my original application. It's a part of my original application.
But
If it's not argued, it's a duty of tribunal.
Mrs. Nag, in the original application, you may have taken 4 points. But in course of hearing, you may have chosen to argue on 2 points.
Just a minute.
Merely because you have
No,
taken
no,
those
no.
points in the original application does not mean that you have pressed those points at the time of hearing.
Just a minute, Your Worship. Yes, it is there. 229, 3.1. It is there.
Yes.
4.2. I can say it's my luck that it's there. Because we know what the tribunal does. Your Worship.
So you have pressed this point.
Yes,
It was recorded.
But no adjudication to that point.
Have you given those documents to Mr. Lal?
Yes, I've given the fresh, the complete set.
The parties at length, 5.1 for the. মানে ওকে ডিলই করেনি জাস্ট 3টে প্যারাগ্রাফে ছেড়ে দিয়েছে অন্য কারো অর্ডারগুলো অন্তত ভুলভাল দিলেও ডিটেল অর্ডার হয়
Page 209 has not been considered.
Yes, not considered.
And page paragraph 4.2 at page 231. The Government of India letter work at fifth line. 21/8/2008 upgraded the pay scale. That is what they say. They take note of this with effect.
Yes, yes.
They take note of this.
Note of this, but no adjudication to that submission has been recorded.
Yes, on behalf of the respondents.
But the tribunal did not consider that whether it is related to my case or not, no adjudication is
Finding on
there.
that.
Finding is not there.
Okay, নাম দেখে না হলে clearly বলে দিচ্ছি। যদি ওরা consider করে to be against the petition, তাকে বলবে that this is মানে এটা বলতে পারে যে this does not apply, but সেটা বলবে। Yes, Mr. Lal. তুমি জিজ্ঞেস করবে কিছু।
Yes.
The given law was on that. Great pay was given. It was not great pay.
Microphone, please.
It was not, in fact, great pay. It was ACP. ACP was extended. There was, and those applicants were linemen come meter readers. They come within the feeder grade of junior engineer. And whereas the applicants are their fitters, they do not come within the zone of consideration. Now kindly have a look at the page 161, the judgment of the lordships, order of the lordship,
161.
my lord. Start from 161, at page 162, my lord.
How does it help you, Mr. Lal?
My lord, this was the grade pay was given on the basis of this order. And the order speaks, my lord, it is referred to 0.5023 of the 5023 at page 162, my lord, of the fifth pay commission. And these benefits are extended just because there is a note. Some of these are applicants are diploma holders, graduates and diploma.
What is your submission on on page 209?
That clearly says non-diploma holders.
Okay. This for non-diploma holders, junior engineers, and not for the chargemen.
Not for the
Chargemen.
chargemen.
These applicants are chargemen. Chargemen are of two types. One of is electrical, one is
Is it not correct that you have given that that pay scale to that grade pay scale to others in the same department? Is that not correct? To other chargemen, that
No.
same grade pay scale,
other chargemen not having the qualification is not there.
not having the qualification.
My lord.
So your other chargemen were diploma holders.
My lord, my lord.
But that 209 says non-diploma holders.
This is for
So
junior
it
engineers.
makes that diploma irrelevant.
This order is applicable only for the junior engineers. And the applicants are the chargemen.
I can clarify this thing. This is subordinate engineering cadre.
Electrical and mechanical, and the qualifications are different and
No.
also the responsibilities and duties. If my lord permits,
This is now, is it correct that you tell us that other non-diploma holders, junior engineers, were they given the benefit of this?
Yes.
Where do we see, where do we find that?
In my rejoinder, your lordship, I have annexed the document.
Yes.
Just a minute, your lordship. Just 1 second, your lordship. Kindly come to page number 221. 221. These people are linemen.
4th February 2012.
Yes. These are linemen come meter readers. Subordinate engineering cadre, all subordinate engineering cadre. We are fitter, where linemen come meter reader.
They are not junior engineers.
Junior engineers. They have been granted the higher pay scale of chargemen without any diploma.
LMR is linemen, meter readers. And you're saying that they were not junior engineers.
They were not junior, they were granted because their promotional post is junior engineer. My promotional post is chargeman. Now they are LMMR, non-diploma. They have been granted the higher pay scale of 209.
And was this document before the tribunal?
Yes, your lordship.
This is part of your rejoinder.
I have also stated, it is recorded, that is also recorded, that similarly placed subordinate engineer cadre employees, they have been granted the higher rate of discrimination. I have mentioned, your lordship. This is mentioned also. 3.2.
Yeah.
Yes, 3.2 and then 3.3 also.
Can't say that.
Last line is 3.3. Actually, they are speaking about the nomenclature. They are not saying that even the 50 commission recommendation, the word used is subordinate cadre, subordinate engineering cadre. These are all these posts, fitter, chargeman, lineman, meter reader, all are subordinate engineering cadre.
That is 209, you're saying?
Yes. 209, no, recommendation I'm saying.
Recommendation.
Which is recorded by the Honorable High Court in the order itself. The recommendation may be seen, it is reflected in the order of the Honorable High Court. Okay, to the point finding the
Yes, at page 162. That's 50.23.
Yes,
something.
yes. Kindly say junior engineer is not mentioned. Subordinate engineering cadre is mentioned.
It just says pay scale of diploma engineers in government. We are recommend yes, for engineering subordinate cadres.
Yes,
That is what it says.
so these people all LMMR, chargeman, fitter, all are subordinate engineering.
You are fitters. All 10 of you, how many fitters? Are fitters.
Fitters.
Page 160.
And it is not that they have not granted, they have granted the ACP, but in a lower scale. And we want that it should be granted in the higher scale, revised scale, I can say.
It was in the electricity department.
Yes.
Oh, you were promoted to the post of chargeman initially. And then what happened? That's I'm looking at 228, paragraph 2.1.
2.1.
So after being promoted to the post of chargeman, your grade pay was 2800. That is what you have stated.
Just a minute.
2.1 at 228.
They were on ad hoc basis, Your Lordship. Ad hoc basis, they were given promotions. And just a minute, Your Lordship. Yes. 2,800. After promotion, we were given.
You were given promotion, but the ACP, the logic behind ACP is that if you are not actually promoted to that post for any reason, but you have completed a certain
12
number of years in the lower post, you are entitled to that ACP. So if you have been actually promoted to the post of chargeman, how are you entitled to ACP?
Your Lordship, not ACP, the scale. I'm sorry, the scale,
You
revised
say-
scale. I'm sorry, Your Lordship, that actually there was other case also, they were granted the ACP. So that was there in my mind. It is promotion and to the post of chargeman, I want the revised scale, which has been granted to other chargemen.
Of chargeman.
Yes. That has not been granted to us only on the ground that we are,
And revised scale of chargeman should be 4200.
yes, grade 4200.
Yes.
My lord, kindly once again come to page 165 of the para 2. After pursuing the recommendation of the Central Fifth Pay Commission in respect of the engineering and subordinate cadres holding diploma, it is in respect of the persons candidates having degree or diploma. It's not that without that.
No, but 209 was not considered.
Right. Kindly,
States that.
Says non-diploma holders.
kindly come to page 186 of our recruitment.
186.
186. And this should be read with,
186.
my lord, this should be read with page 137. Where by the order number 621. Order number 621, it relates to 17 persons at page 137. They are all LMMR. My lord. My
Yes,
lord,
sir, you have given that benefit to LMMRs also.
my lord, my lord, my lord. My lord, 137, my lord. LMMR, it was given to my lord.
Yes, yes, no, the document which we have been shown at page 221, so that benefit was given to LMMRs.
Yes, my lord.
221.
My lord, why it was given, my lord? It is, the answer lies in at page 186. 186. 186. At last column 11, my lord, promotion. The lineman from meter reader having service of 8 years. This is the promotional. This is the feeder date of the G. This is the feeder date of the G.
Yes.
And they could not get, because they were not degree holders, they could not get the base case. So in terms of the ACP scheme, it was extended. This is what the order 137, order of 621 at page 137 shows.
Anything else, Mr. Rao?
Minutes.
I can clarify this, Your Lordship. Yes, yes. Your Lordship, junior engineer, kindly see the qualification. Degree or diploma holders in electrical engineering or mechanical. That qualification is prescribed. But for chargemen, even that qualification is not required. It is only should have not less than 10 years experience in the trade, must have passed 8th standard. The qualification is so low for chargemen. For the junior engineer, is diploma and degree. For junior engineer, it was diploma and degree. But because of the government of India's order, the LMMR, who are not wanting diploma and degree, they have been granted the grade pay of the post of junior engineer. Though they are not having a diploma or
Just one minute, let me run it back. 186. 186?
yes, Your Lordship, yes. 186, what I'm saying, for the post of junior engineer, the qualification is degree or diploma.
Last 12 paper.
Degree or diploma.
Diploma. And LMMR is the speeder post.
Yes.
Lineman commit everywhere. Now for chargeman, next page is chargeman. Kindly see those qualification itself is not there for the post of chargeman. No diploma, neither.
Only 10 years.
Only 10 years and this must have passed 8th standard.
10 years should possess diploma in mechanical engineering.
Yes. In the trade, all should possess diploma or this thing.
Yes.
We have completed 10 years and thereafter we have been given promotion. What my contention is that these people, junior engineers, they were not the LMMR. They were not granted that particular pay scale of junior engineer because diploma and degree was required. But when the government of India cleared that it's not required, they have been granted. So for us, the Honorable High Court has already held that for the post of chargeman, that is subordinate cadre, diploma or degree, they are entitled to it. Now connecting that to the decision of the government of India, that is 209, it is very clear that it is not required for subordinate engineering cadre. So why we should not be granted?
And this is part of what? The one which you're showing, it starts from which page? 184.
Reply.
No, this 184 is what?
Recruitment rules.
Recruitment rules.
Recruitment.
Starts from which page? Yes, from 183. 183. Here is December 1985, 1975.
Yes, a very old one.
Yes.
Now it has been revised also.
In the minutes.
It is reviewed.
So this was part of your rejoinder?
No reply. No reply.
Their reply. Very good.
So that was discussed those other important.
to differentiate further.
Yes. First
Can you have a look at the minutes at page 206?
minutes.
Minutes at 206. This scale was given to junior engineers, the bold letter, my lord, at para 1 itself,
Yes.
in 5,000 to 8,000, in completion of 12 years. The junior engineers having completed 12 years of service in the cadre, since the amendment for the recruitment board of engineers made in the year 2004, they were entitled to ACP. Well, it was to
Got to SCP.
my
They are not asking
They are
for
not
SCP.
asking for SCP.
They are asking for revised scale of charge.
They are asking for revised scale of the charge band.
Yes.
my lord, they are not, they are the chargemen. They are the chargemen of electrical and they are the fitter. They have come from fitter grade. They are not in the fitting.
The judgment and order dated January 4, 2024 in passed by the Central Administrative Tribunal, Kolkata bench, holding its circuit at Port Blair in OA 351/00720/2019/AN is under challenge at the instance of the original applicants. First up, before the learned tribunal, the original applicants prayed for setting aside and quashing the order dated 17th of May, passed by the Superintending Engineer, Electricity Department, Andaman and Nicobar Administration, and for a direction upon the respondent authorities to grant the great pay of rupees 4,200 instead of 2,800 from the date of their promotion to the post of chargeman. The paragraph. The original applicants were initially appointed as fitter in the electricity department. Subsequently, they were promoted to the post of chargeman and were awarded the great pay of 2,800. First of the it is this case of the original applicants that the junior engineers of the electricity department were also not awarded the upgraded pay scale on the ground of not having the degree of diploma. First up, the Government of India, Ministry of Power, New Delhi, by letter dated 21/10/2008, granted the scale of 5,000-8,000 to the non-diploma holder junior engineers of the electricity department with effect from 1/1/1996, putting the non-diploma engineers at par with the degree and diploma holder junior engineers. The original applicants alleged that one Sri Jagjivan Lal, working as chargeman in the electricity department, who also did not have a degree or diploma in electrical or mechanical engineering was awarded the great pay of rupees 4,200. Full stop. Paragraph. The learned tribunal by the learned tribunal, comma, by the order impugned, comma, rejected the claim of the petitioners on the ground that they are non-diploma holders and therefore the benefit of either fifth Central Pay Commission report within brackets paragraph 50.23 and 50.24 or those granted by the Hon'ble High Court in other writ petitions are not applicable to them. To stop paragraph. This is now learned advocate appearing for the petitioner / original applicants draws the attention of the court to the notification dated 21st of August 2008. 21st of August 2008 in support of a contention that the ministry has decided to grant the upgraded scale of pay of rupees 5,000-8,000 to the non-diploma holders, to the non-diploma holder junior engineers of the electricity department of Andaman and Nicobar administration with effect from 1/1/1996. Full stop. By referring to the recruitment rules, she submits that the recruitment rules
180.
being recruitment rules by notification dated 12th of December 1975. She submits that the qualification required for the post of chargeman is 8th standard or no 8th standard, and
Certificate.
and he or she should have not less than 10 years experience in the trade or should possess diploma in mechanical engineering with 2 years experience or should possess a trade certificate in the subject from a recognized institution with 7 years experience. Full stop. She therefore submits that she therefore submits that it is not obligatory on the part of it is not obligatory to have the diploma or degree in order to be promoted to the post of chargeman. Full stop. Paragraph. The learned advocate appearing for the respondent administration আচ্ছা তার আগে লিখুন this is not further submits that now further refers to the order number 299 dated 14th of February 2012 in support of a contention that several other LMMR who also did not possess the requisite degree or diploma were also granted the great pay of rupees 4,200. LMMR, linesman meter reader, was short LMMR. Paragraph. Mr. Lal, I'm an advocate representing the administration, refers to the what is the earlier order where that paragraph 50.23, page 161, refers to the refers to an order of a coordinate bench dated November 30, 2012, and in particular refers to the Fifth Central Pay Commission recommendation and in particular refers to clause 50.23 of the Fifth Central Pay Commission recommendations. Full stop. Not full stop. And submits that unless the diploma or unless the applicants possess the degree or diploma qualification, they are not entitled to the benefits of the state pay structure. First up, heard the learned advocates for the parties and peruse the materials placed. After going through the notification dated 21st of August 2008, this court finds that the Government of India, Ministry of Power, by notification dated August 21, 2008, decided to grant the upgraded scale of pay of rupees 5,000 to 8,000 to the non-diploma junior engineers of the Electricity Department of the Andaman and Nicobar Administration with effect from 1/1/1996. It further appears from the order impugned that the said notification was relied upon in course of hearing of the original application. However, the impugned order does not return any finding as to the applicability or otherwise of the said notification dated 21st of August 2008. Full stop.
এটাকেও কনসিডার করেন সিমিলার টু 21 টা part of the reference.
This is the part of 221 is part of your reply.
Original application.
It was part of the original application.
209. No,
No,
221.
221.
That similar people were
Similar people.
rejoined.
It further appears that the office order number 299 was also placed before the order number 229 dated 14th of February 2012 was also relied upon, no, was also part of the rejoinder filed by the original applicants before the tribunal. The impugned order also does not take into consideration the fact that LNNR were granted the were also granted the great pay of 4,200 in spite of the fact that they did not possess the diploma slash degree in engineering. Full stop. Jagjivan was the chargeman
Yes.
in the original
He was
application.
promoted to the post of chargeman subsequently.
Yes, yes.
He is the person who is receiving higher pay scale. Yes,
I have referred to that.
yes.
So as the page in the original application.
Even
You have
just
stated
after that also it is there. 222 may be seen.
222.
Yes, I have obtained the information of Jagjivan Lal,
RTI.
Oh, yes.
RTA. As per service record of Jagjivan Lal, retired chargeman.
Yes, that is there. Show me your averment in the original
Yes,
application.
Yes, yes. Yes.
I have recorded that, but show me that paragraph. I think I have recorded from the impugned order.
তুমি ইনফিন নোটে রেফার করে বলেছি।
Mhm. Now, since it has been alleged that one
Yes.
Jagjivan Lal, who has since retired as chargeman, was also granted the great pay of 4,200 in spite of the fact that he did not in spite of the fact that he only had the qualification
Certificate.
of having passed AISSE and 2 years course of electrician from Model Training Institute, and would be evident from the reply to the information sought for under the provisions of the Right to Information Act 2005. This court finds that a similarly situated employee was granted the great pay of 4,200, and the learned tribunal did not return any finding as to how the petitioner could have been denied such benefit. Full stop. Materials are already there. There is no necessity to file additional document.
Nothing, all.
Full stop. Since the materials are already before the learned tribunal, this court is of the considered view that the matter should be remanded to the learned tribunal for deciding the matter.
Similarly situated persons were given the benefit. There is no discrimination.
Before that, upon going through the notification dated 21st of August 2008, this court is of the prima facie view that the petitioners are entitled to the upgraded scale of pay of rupees 5,000 to 800, 5,000-800.
8,000.
Sorry,
8,000.
5,000-8,000. So, stop. We are also of the prima facie view that Jagjivan Lal, a similarly situated employee, was extended the grade pay of 4,200 without having the diploma or degree in engineering. Full stop. Paragraph. The order number 299 dated 14th of February 2012 also goes to support the case of the petitioner that they are entitled to the grade pay of rupees 4,200 even without possessing the diploma / degree in engineering. Full stop. For the reasons as aforesaid, we are of the considered view that the tribunal should be directed to decide the matter afresh in the light of the observations made in this order, in the light of the observations and findings in this order. Full stop. The impugned order is accordingly set aside. Full stop. The learned tribunal is directed to rehear the original application is restored to the file of the learned tribunal, and the learned tribunal is directed to rehear the said original application upon giving an opportunity of hearing to the respective parties and pass a reasoned order in the light of the observations and findings given herein before. As expeditiously as possible, but positively within a period of
6 weeks.
6 weeks,
Yeah.
within a period of 6 weeks from the date of receipt of a server copy of this order.
Deeply obliged, Lordship.
Disposed of. With the above observations and directions, the petition stands disposed.
Item number 6. This year, 1 of 2024.
Milord, there is a correction, Milord. I have
Sorry?
correction with respect to the name of the accused wherein the order was passed by this honorable court. Instead of BARLA, it should be BERLA, Barla. I have wrongly mentioned in my cost title as BARLA. It should be BERLA.
How do we know that, Mr. Elango? Show us the document, please.
Milord,
Show us the document.
as per the charge sheet, Milord, it's Salim Berla. I mentioned it as Barla.
No, show us the charge sheet.
It is mentioned, Milord. In the top. Salim Berla, BERLA. And the father's name is?
So we have already passed this order.
Yes, Milord.
What is
It has to be corrected because when I,
that is the only prayer.
yes, Milord.
No, see again, enlarge your petitioner and bail. Yes. You're saying the name has to be corrected.
Yes.
And then, well, but what is your,
Graciously, please to.
Mr. Elango?
There, Milord.
We have already disposed of the application by way of the order dated 7th February.
Yes, my lord.
So again, we have filed a fresh application for bail.
No, my lord, it's
No?
not a precious.
Okay,
It's the
correct.
CRAN is there.
Oh, the CRAN.
CRAN 1.
CRAN ta kota hai? There, this is an application. Yes, this is an application for correction, for correcting the name of the petitioner as Salim Berla, BERLA, instead of Salim Barla, Barla, stop. By the order dated 7th February 2024, comma, we had allowed the petitioner's application for bail. Stop. The order sheet. The order, however, mentions the petitioner as Salim Barla. Stop. Upon perusing the charge sheet, comma, which also mentions the petitioner as Salim Barla, Berla, comma, Plan 1 of 2024 is allowed and disposed of by making necessary corrections to the order dated 7th February 2024. Stop. The petitioner is to be recorded as Salim Berla, Berla, quotation marks, wherever applicable, instead of Salim Barla. Stop. Let these corrections be made to the order, and this order is to be, and the order is to be incorporated and read with the order dated 7th February 2024.
Grateful.
My presence may be noted.
Yes, yes.
Item 7. Ready, Your Honor, 23.
দেখেছিলাম ভুলে গেছি। Mr. Kabir and Mr. Kumar, Mr. Mohammed, to be honest, I haven't had a chance. I have to say I, because I can't hold my learned colleague responsible. I haven't had a chance to go through the notes. All right. So we will keep the matter on Monday.
My lord, on Monday, I may not be there, as I am leaving today for delivery. My additional people will be here too.
Very good. Yes, yes. Sorry, Mr. Mohammed, because I didn't just find the time to do this. Although the notes are already on record, although the notes filed by learned counsel are already on record, comma, one of us, within brackets, MOUSHUMI BHATTACHARYA J, close brackets, did not find the time to go through the notes. Stop like this matter on 12th February 2024.
All right.
Item 9, Hon'ble proceedings, 17 of 2023.
petitioner তোমার কথা শুনতে পেয়েছি যে তুমি যাবো হ্যাঁ দিদি petitioner যাবো
This is that matter which has come back on remand from Supreme Court, my lord, where the division bench, my lords, had dismissed the appeal, although there was no one to, because, my lords, of the strike.
Yes,
But
yes.
Ms. Nag had appeared on the last occasion saying that she.
Justice Nishita Matre.
Yes, yes, my lord. But Ms. Nag had appeared on the last occasion saying that she has received instructions, my lords, but I don't know, she's not here to.
Receive instructions.
My lords, may I have the last order? My lord has recorded.
Yes, yes. No, the last order doesn't say that, notes the appearance of Mrs. Nag. So, Mr. Chakraborty, what to do? Next circuit bench? Yes, no one appears for the respondents today. Although, learned counsel had Submitted that council have received instructions to appear in this matter. Stop. Next, list this matter before the next circuit bench.
Well,
Item number 10. We are at 87 of Bangalore.
Lordship, I appear for the state.
No one appears for the appellant. Item number, which is this, 10.
I appear for the state.
My lord, I'm
Oh, you're with the appellant, sorry, sorry.
My lord, today I am appearing for the respondent because he has contacted me today only. So
There was a specific direction upon this prosecution to submit a report that I have informed him about the listing of this case. So I'm filing the report as well.
Listing of the case? Yes. Very well, learned counsel appearing for the respondents. Seeks seeks an adjournment on the ground that council has received the papers. What did you say, yesterday, today, or day before yesterday? Which one?
yesterday, yeah.
Received the papers only yesterday. Stop. Next, list this matter before the next circuit bench.
All right.
Obliged. Let the report be kept, your lordship, because I was.
Why should this report, you file it before the bench which hears the matter? I would not to take it away. Very well. Yes, learned counsel appearing for the appellant is given leave to file the report before the concerned bench which takes up the matter for hearing.
वापस कर दीजिए report.
I'll also accept same.
Yes. Yes, we will sit. এখানে Yes, very well, at 12:30, single bench.
Yeah. Idea number two. 979 of 933.
I am appearing for the petition.
In view of the above reasons, there is a presumption of arbitrariness in view of the above reasons. In the exclusion of the members of the petitioners from the benefits of the office memorandum dated 22/9/2017, the exclusion on the ground of alleged ineligibility of the petitioners clearly appears to be an afterthought and contrary to the direction of the division bench. The exclusion is also opaque, that is without reasons and hence arbitrary. The decision of the full bench of the Calcutta High Court in Avadesh Singh was altogether on a different issue, which was whether the petitioners who sought for regularization, absorption in the service of Eastern Railway could directly approach the High Court by filing a writ petition under Article 226 of the Constitution, WPA so and so, and to common judgment are accordingly allowed and disposed of by the respondents, particularly PBMC, to provide the benefit of 1/30th of pay of the minimum of the relevant pay scale plus DNS allowances to the members of the petitioners in the writ petitions in the terms of the office memorandum dated 22/9/2017. The benefit shall be extended to the petitioners / members of the petitioners within 4 weeks from the date of this judgment.
Obliged.
Item 4. WPA 1083 of 923. Your Lordship. 4 to 7, same order, Your Lordship.
No,
Let the Honorable Division bench.
my lord has already heard that, my lords, and
Sorry?
this is that Sarva Siksha Abhiyan. So my lord has heard sitting in the division bench, my lord.
So what?
So as your lordship thinks,
Is it, can we dispose of in the same line?
No, what is disposed of in the same line? Give me that.
my lord had sent it back for representation and kept the point of maintainability open, but then I don't know how that would.
Mrs. Now you have to show me the order. How can I just say disposed of?
Your Lordship. Just a minute, Your Lordship. MAT 5 of 2024.
Yes, yes, but I need to see the order.
Your Lordship.
আছে কি তোমাদের কাছে?
Four, five, six, all three matters, right?
Mrs. Now you should have told my court officers to get out the order.
Your Lordship.
In the
Your
full.
Lordship.
7 also.
4 to 7.
Yes, so what are the prayers in these three petitions?
Same, Your Lordship.
Same means what?
That for appointment regularization in the post and all those things, Your Lordship.
So you want an order, because in the division bench we directed that we gave liberty to the
Petitioner.
to petitioners to make a fresh representation to the competent authority.
Yes, sir.
So what do you want in this case?
Exactly the same order, Your Lordship. Because here also facts are exactly same.
So I can pass one order or separate orders?
Your lordship, it depends.
Separate orders.
Separate order.
Very well. এটা কোনটা ডাকলে? চার ডাকলে? Yes. Then counsel according to the petitioner submits that the petitioner seeks regularization seeks a direction on the respondents to consider the petitioner's case for regularization in the post against which the petitioner has been working for a considerable number of years. Stop. Council places an order passed by a division bench in this circuit dated 7 February 2024, which had considered a similar, an identical prayer, as well as the issue of was it regularization as well?
Yes, yes.
Regularization of the petitioners before the division bench who in their respective posts. Stop. The division bench, after considering the issues, after considering the cases put forward by the parties, the division bench granted liberty to the petitioners to make a fresh representation to the competent authority, competent authority, for regularization of their posts in Samagra Shikha Abhiyan, just take serious spelling please, where the petitioners claimed to have been engaged for the last 17 years. Stop. Next, council submits that the writ petition, that since the writ petition involves the same issue and relief, the writ petition will be disposed of in terms of the order passed by the division bench. Stop. Next, WPA. Yes, 1083 of 2023. But we had passed a common order. I had passed a common order last time, Mr. Chakraborty.
I have not, whatever your lordship. voted.
Yes, just make one order. The writ petitions, just name the writ, give the numbers, individual numbers are accordingly disposed of by giving liberty to the petitioners to make a fresh representation before the competent authority for regularization of their services in the post of Samagra Shikha Abhiyan, where the petitioners have been engaged for the last several years, for a substantial number of years. Stop. The petitioners are also given liberty for to pray for framing of a scheme for job protection for the petitioners. Stop. Did we make any time frame? No. Yes. The competent authority shall dispose of, next paragraph, dispose of the representations, if made, by the petitioners, within a period of 4 weeks, within a period of, what is a good time, Mr. Chakraborty?
As long as your lordship, as your lordship deems.
Yes, within a period of, yes, Mrs. Nag?
3 weeks, as granted by your lordship. Same period.
3 weeks from the date on which the representations are sent to the competent authority. Stop. The issue of jurisdiction, no, this will not apply. Yes.
Blair.
My lord, that observation regarding maintainability, which you lord have made.
But here there is no tribunal order.
The difficulty is going to be, my lords, that here I would be raising the objection as to maintainability, that this writ is not maintainable, they have to go to tribunal. So my lords has sent it back for representation.
Yes, the objection with regard to the maintainability of the writ petition is kept open. But the writ petitions have said that they've already
It goes back to a representation, an order will be passed on the representation. So when they again challenge that order, my lord, before the High Court directly, then they will
Yes,
say.
just give a line, please. As submitted on behalf of the respondents, comma, the issue of maintainability of the petition is approaching the High Court. Comment will be kept open to be considered at an appropriate stage.
But
Yes, next.
judgment.
Item 8. 85 of further decree.
My lord, I am.
Mr. Chakraborty, have you found the arbitration clause?
Yes, my lord, it has been served, my lord.
Yesterday we were trying very hard, that's why I
It was
asked.
not there in the, because it was not there in the brief, my lord. It has been.
It is there, my lord.
subsequent.
Yes.
Yes.
Did you try hard as well?
No, my lord, I know, my lord, by mistake I did not include.
Yes, where is it?
I see. Clause 25.
You're filing some, what is this?
This is general condition of contract, my lord. It's part of the agreement.
Clause
Clause
25.
25, my lord.
This is GCC of which year?
2008, my lord.
But hasn't it undergone further modification?
No, my lord, this agreement was pertaining to 2008, my lord.
Clause 25.
25, my lord.
Yes.
Except where otherwise provided in the contract, all question and dispute relating to the meaning of the specification, design, drawing and instruction herein before mentioned, and as to the quality of workmanship of material used on the work, or as to any other question, claim, right, matter or thing whatsoever in any way arising out of or relating to the contract, design, drawing, specification, estimates, instructions, order or these conditions or otherwise concerning the work or the execution or failure to execute the same, whether arising during the progress of the work or after the cancellation, termination, completion and abandon thereof shall be dealt with as mentioned herein under. If the contractor consider any work demanded on him to be outside the requirement of the contract or dispute any drawing regards or decision given in writing by the engineering in charge or any matter in connection with or arising out of the contract carrying out the work to be unaccepted, he shall promptly within 15 days request the superintending engineer in writing for written instruction or decision. Thereupon the superintending engineer shall give his written instruction or decision with.
Where does it talk about the arbitration?
No, no, on the side itself, my lord will say clause 55 left hand side, settlement of dispute and arbitration, my lord.
How many tiers does it have before arbitration will start?
My lord,
How many tiers, how many levels does it have?
only one level, my lord. We have to write a letter to the superintending engineer, my lord.
Have you done that?
Yes, my lord.
Roman.
1 minute.
However, they have rejected, my lord.
1 minute, 1 minute. So you have come at the stage of rejection by the superintendent engineer.
My lord.
What about, and have you appealed to the chief engineer?
My lord, this is an autonomous body. When we filed before the superintending engineer, he sent it to the chief engineer. Chief engineer said it is an autonomous body, we have got nothing to do. That all communications are enclosed, my lord. Ultimately, my lord, because I have submitted it on tender.
So the clause provides that if the engineer fails to give his instructions, decision in writing within the whatever, that 1 month or whatever,
My lord.
Or if the contractor is dissatisfied with the instructions, that is, if the decision is given and you are not happy,
My lord.
then the contractor may within 15 days of the receipt file an appeal before the chief engineer,
My lord.
who shall again a hearing given to you.
My lord.
And then again, the chief engineer will give a decision within 30 days. If the contractor is dissatisfied, then the contractor within a period of 30 days shall give notice to the chief engineer for the appointment of arbitrator.
My lord.
So which stage have you come to the?
My lord, here it is an autonomous body. Chief engineer is not the.
But what is an autonomous body?
This is a Jila Parishad, South Andaman district. There is no chief engineer. Superintendent engineer is the highest engineering officer under the autonomous body.
Yes.
So when on 10th of February 2023, we filed this, we sent it to the chief engineer. Chief engineer said that we are not concerned with this. This is your autonomous body. You are the authority. You do whatever you want.
No, show me that. So, anyway, so what is your submission?
So, my lord, chief engineer,
Which clause in the contract refers to the GCC?
my lord, kindly come to page number 26, my lord. Page number 26. Schedule F, my lord.
26?
26 of my application, my lord, inner page 15 of the agreement. Schedule F, reference to general condition of contract.
Yes.
Schedule F, my lord. Reference to general condition of contract.
So no, does this mean that the agreement is governed by the GCC?
Yes, ma'am. My lord, agreement, GCC is part of the agreement, my lord. When
Yes, where do I get that from?
my lord, from schedule F, my lord has seen at page 26, it says general reference to general condition of contract. Now, my lord, the GCC which I have handed to my lord, if my lord comes to page 3, they are also.
Why are you entering the agreement with the
Jila Parishad.
Zilla Parishad?
Jila Parishad, my lord.
Yes. Yes. Yes.
So, my lord, GCC is part of the agreement, my lord.
So what is your next contention? There is a 21 notice.
That is that starts from page number 61, my lord.
Yesterday you had said 57.
57 is, yes, my lord, it starts from 57.
61 is a separate letter.
My lord has, yesterday also my lord has asked me, my lord, page 60, they have enclosed it, my lord. This is part of, that's why I have made that submission. Page 60, if my lord sees, this 61 is part of page 57 onwards. It was enclosed, my lord.
So this you wrote to the superintending engineer.
My lord.
And then what happened?
Thereafter, my lord, we have referred it to the chief engineer. Ultimately, my lord, page 91 was rejected. And immediately I approached this court, my lord.
91.
91, my lord. July 2023, my lord.
Where is the reference to the chief engineer? Page 91.
There is no reference, my lord.
No, then you're showing me page 91 when I asked you.
91 is the rejection order, my lord. Last line, if my lord sees.
As well, so after that, you have to go to the second authority.
My lord, here in autonomous body, there is no chief engineer, my lord. That CPWD manual is pertaining to the Central Public Works Department, my lord. They have adopted it.
That letter is at 89. The letter of the chief engineer to the superintendent engineer.
He says, I have got nothing to do with this. This is an autonomous body.
So they referred it to the chief engineer 88 and the chief engineer responded.
1 minute, Mr. Chocolate. Very well. Yes, Mr. Chocolate, what do you have to say?
My lord, my contention is, my lord, what is also recorded in the letter at page 91, my lord. But my lord, this is hit by res judicata, my lord. The same claims have been decided earlier and awarded in their favor.
Where is that award?
My lords may see it's annexed with the affidavit in opposition, annexure R6, which is at page, my lord may see page 26.
This is the award.
Encloses the award. Award is at 28.
28.
28. Corner, the top corner of the page extension. And the decision is page 76 onwards. And the final portion of the award dealing with the sums awarded, that is at page 84.
No, there was a 33 after that. There was a correction, application of correction after
Yes,
that.
yes. That order is also annexed. 89. And at 91, my lord will see the correction. That is on the computation of interest.
30th December 2017.
Yes, ma'am.
So you're saying that they have asked for the same sums, same amount of money.
My lord, that is what the stand of the department is, that there is in respect to the same contract and that this has already been decided, all the disputes have been decided by this award, and the amount has been paid in the course of execution. So, my lords, according to the department, my lords, there is no arbitrary dispute.
What is the date of the award? 30th December 2017.
30th December 2017. And there was a correction as corrected on 20th January 2018. And this was subsequently challenged, and in execution, they have recovered the money.
Yes, Mr. Sunil Kumar.
My lord, the first on 27th of May 2016, this petitioner made two applications, one for appointment of arbitrator and another application stating that now when the moment I will undertake the work and complete the work, thereafter whatever arbitration arises, that I will claim separately. That document I enclosed. And the initial arbitration was pertaining to claim of delay in making payment of materials brought by the petitioner, expenditure incurred by the petitioner for storage of those materials, expenditure incurred for watch and guard. This was the claim, my lord.
Where do I find that?
Page 5, para 14. And the claim is also there, my lord. In my pleading,
I'm not pleading. Where will I find that these are new claims?
Acha, new claims, my lord, will find. New claims is at 57, my lord, but 57 on 61 onwards, new claims. 61 onwards, my lord.
No, you are saying that you are not hit by res
Yeah,
judicata.
absolutely not. Earlier, the claim was with regard to the document, the materials which were procured, store and watch and ward. That was the claim at that junction. And page 61, my lord, may kindly come to. And in my short note also, I have given page 63, my lord.
Yes,
Page 63 is claim number 1, my lord. On account of, what is meant?
yes,
On account of payment of interest for the delay in releasing, adjusting the EMD ban upon the work in terms of section 73 of the Indian Contract Act. Second claim is on account of loss of profit in terms of section 73 of the Contract Act for prolongation of a contract. Third one is on account of payment of interest for the delay in payment of part 2 running bill in terms of section 54 read with section 73 of the Indian Contract Act. Thereafter, my lord, on
very well. Show me that these claims compared with the first set
my
of
lord,
claims
my lord, my lord.
which were awarded.
My lord, may kindly come to page 47, my lord. Yes, ma'am, 47.
Yes,
Claim on account of payment of interest on the blocked sum of money to the extent of rupees so and so, from the date on which I have informed the
what is blocked sum of money?
my lord, the moment he procured the materials and it was arrived at port door, my lord, immediately as per the CPW, he is entitled for 90% of payment of the materials brought, my lord. That has been
The contract was that you would bring in the material.
install, commission. But since they did not provided the land for years together, I had to put those materials on storage.
Yes.
For which I had to incur watch and ward and all, my lord. For that, the initial claim was made. Second claim was after the completion of the work. Now, my lord, this is the first claim. I have specifically stated, I have informed about the arrival of the RO plant because it has to be procured from mainland, my lord. Second claim, my lord, page 48.
Yes.
Claim on account of storage of material, ground rent, charge for an area of so and so, so and so. That is with regard to storage. And third one, my lord,
Yes.
third one is watch and ward, my lord.
Yes.
Fourth one, my lord, fourth one, my lord, will find claim on account of work done at so and so.
What's on ward means what?
My lord, these materials were brought. For that, for the protection of these materials, I have to engage persons for watch and ward. And my lord,
That is what? What is what?
my lord, my lord, that is what is in nomenclature used in this CPW manual and all, my lord. This
Yes.
thereafter, my lord, claim number 4 is, my lord, initially there was anything else? No, my lord. So, my lord, both are entirely different. And in their affidavit, my lord, once they started concealing, but they inadvertently, my lord, they have said that paragraph number. In paragraph number JJ, my lord, at page 11, they themselves says,
Yes.
now the agency, page 11, my lord, now the agency has raised 10 numbers of claim for an amount of rupees 1 crore and so, and has also requested for appointment of arbitrator, which is under process.
Page 11 of the opposition.
My lord. JJ, my lord, last at the bottom.
Yes.
Now the agency has raised 10 claims for an amount of rupees so and has also requested for appointment of arbitrator, which is under process.
This is in respect of the present.
Yes,
The second claim.
yes, my lord. Earlier it was 4 claims. Plus, now this time there are 10 claims, my lord. This is after completion of work. That was, and my lord, it can't be, my lord will find 2016 itself, I have made 2 applications. One for appointment, second, let's say, I reserve my right So go for arbitration once I undertake the work. That application, that letter is, my lord, at page 56, my lord, 54.
Yes.
So, my lord, there is no question of res judicata, my lord.
What is the claim amount?
1 crore 71 lakhs.
There's one submission, my lord.
Yes.
This is not a concession, my lord. This, my lords, will see the affidavit in opposition. It is either a mistake or this refers to the proceedings before your lordship. I kindly see the next paragraph, my lords. It is clearly saying that the is barred by law with res judicata waiver estoppel, and the application should be dismissed. This is not a concession at all. But my lord, be that as my humble submission will be, my lords, if your lordships do not find that this is expressly non-arbitrable, in that case, my lords, all these points may be left open to be decided before the arbitrator. Because my lords, section 11, my lords, I just one judgment, my lords, I wanted to place. So I'm relying on 25 to 28, where my lords, first part of the inquiry, my lords, is whether the parties to the agreement.
This is that I have the legal judgment.
Yes, my lords is well, my lords, I don't.
Where it was a settlement, my lord.
No, I'm not saying, I'm only
Where the
submitting.
parties agreed for something, subsequently the party raised the issue, therefore.
This is by Justice Narasimha, yes.
Yes,
No,
yes, my
I'm
lord.
only saying that, my lord, since the inquiry, your lordship, my lord, if I may be presumptuous enough to make a submission.
Yes.
My lord, that because the inquiry, my lords, is restricted to for the purposes of section 11. So if my lords arrives at a conclusion that this is not an ex facially non-arbitrable dispute, in that case, my lord, the point of res judicata, whether it is there, it is not there, my lord, that my lord may clarify that the arbitrator will decide that, my lord. Should not be in a sense that if my lords goes into the entire inquiry and holds that res judicata is not applicable, my lords, then that would prejudice my lords.
Yes.
Respondent.
The amount is, my lord, 1 crore 71 lakh 74,523. And I have given a note also, my lord. 1 crore 71 lakh.
The petitioner seeks appointment of an arbitrator by way of the present application filed under section 11. Within bracket 6 of the Capital Arbitration and Conciliation Act, 1996. Stop. Next, the petitioners of the relief claimed arises out of an agreement, capital A, dated, give me the date, please.
My lord. This is December 2008, my lord, but December 2000, in agreement there is no date, but this is.
Agreement bearing number AC/ZP/ just see it, please, page 14. 2008/2009. Stop. The agreement does not mention a date, but the court is informed that the parties executed the agreement sometime in December.
Yes, madam.
In December 2008. Stop. The scope of the agreement was that the petitioner would install an RO plant with distribution pipeline at Dhanikari,
Dhanikari, my lord. Yes, my lord.
under the respondents / Zilla Parishad, South Andaman District. Stop. The first page of the agreement mentions the amount put in tender, the earnest money, and the time for completion of the agreement. Stop. Next, the petitioners, the petitioner, learned counsel opinion for the petitioner alleges that the petitioner could not, that the petitioner, despite procuring the material for the commissioning of the plant, could not make much headway, one word, headway with its performance since the respondent failed to hand over the land in question to the petitioner. Stop. Council submits that the petitioner therefore had to make arrangements for watch and ward, quotation marks, watch and ward of the material already brought to the site, procured and brought to the site, and was hence constrained to make a set of four claims
Well, four claims.
before commencement of the contract. Stop. Council submits that the present set of 10 claims which were made by invocation of the arbitration agreement to the respondent on 10/2/2023 were made after completion of the contract and on a completely different set of grievances, of disputes. Stop. Next, learned counsel appearing for the respondents / Zilla Parishad submits that the petitioner's claim for appointment of an arbitrator is hit by res judicata since an arbitrator, since a previously appointed arbitrator already adjudicated on the petitioner's claims and made an award on 30/12/2017 as corrected on 20/1/2018. Is it 20 or 28?
21.
20/1/2018. Stop. Council submits that the petitioner's claims have already been allowed in execution proceedings. Stop. Next, the records before the court shows that I should put counsel in my court waiting for their matters on notice that in the principal bench I don't allow counsel to yawn in my court. All right, and particularly not to yawn with their mouths uncovered. Civil and lasting shows that the agreement executed between the parties was to be governed under the general conditions of contract, capitals, for Central PWB Works, 2008. The relevant part of the agreement refers to clause 25 of the GCC, which provides for settlement of disputes and arbitration. Stop. Construction of this clause is no longer material, is not called for at the present stage, since the parties before the court have already gone to arbitration, participated in the arbitration proceedings, and the arbitration has culminated in an award of 30/12/2017/21/2018. Stop. The only question which remains, the only question before the court, next paragraph, is whether the petitioner's claims would be hit by the principles of res judicata. Stop. Next. This court is of the view that an issue of non-arbitrability would be on the grounds either of deadwood, quotation marks, or an ex facile case of limitation being established by the party who opposes arbitration. Stop. All other issues, including that of res judicata, are within the domain of the arbitrator, where both parties would have their respective opportunities to argue the issue and permit the arbitrator to come to a decision. Stop. Next, in any event, the set of claims which were decided by the learned arbitrator appear to be totally different from the present claims which have been outlined by the petitioner in its invocation notice under section 21 of the 1996 Act on 10/2/2023. Stop. Even cursory perusal of those claims makes it clear that the claims were raised post-contract. Post-performance. Stop. Next, the court has only to see whether there is once, the existence of the arbitration agreement is established and the dispute is found to be directly relatable to the arbitration agreement, nothing much remains for a section 11 for a referral court, for a section 11 court to decide. Stop. Don't write referral, section 11 court to decide. Stop. It is apparent that there is indeed a dispute between the parties. Stop. This would be underscored one word, underscored by the respondents reply to the invocation notice, whereby the respondents, where is that reply?
91, my lord, page 90.
Wherein the respondents have summarily, SUMMARILY, summarily disputed the petitioner's claims on the ground that the petitioner has already received, that the department has already paid the petitioner. On the ground that, on the ground that the petitioner has already been paid by the department in execution case number 4 of 2018. Stop. Next, given the nature of the response, comma, the reply, comma, the parties would hence fall both under subsection 5 within brackets and 6 of section 11 of the 1996 Act. Stop. Next, AP 5 of 2023 is accordingly allowed and disposed of. No, it is made clear, just one line, it is made clear, but all questions, comma, including that of res judicata, comma, shall be kept open for adjudication in the arbitration proceedings. Stop. Next, AP 5 of 2023 is accordingly allowed and disposed of by appointing blank to act as the learned arbitrator for resolving the disputes and differences between the parties in terms of the arbitration agreement, and subject to the learned arbitrator communicating his consent in the prescribed format in accordance with the schedules, capital S, to the Act within a period of 3 weeks from the date of communication of this order to the learned arbitrator. Stop. The petitioner's advocate on record will forward the requisite details of the petitioner to the learned arbitrator along with the communication as directed.
My lords, just two submissions, my lords. First, my lords, where my submission is being recorded, my lords, if your lordship, if it pleases your lordship, my lords, then constructive res judicata and or constructive res judicata, only where my submission is being.
There are recorded respondents, hit by res judicata or something I said. Hit by res judicata / constructive res
My
judicata.
lords, my second point is, my lords, if my lord sees the arbitration clause, my lords, this is actually not hit by Perkins, because my lords, this talks about appointment of sole arbitrator by the chief engineer CPWD. So my lords, CPWD and the respondent are not one and the same, my lords. In those circumstances, my lords, my lords, is your lordship's prerogative. My submission, humble submission is, my lords, that the party should be referred to arbitration in terms of the arbitration clause.
No, Mr. Chakravarti, once it's 11, this is court's prerogative.
Yes,
to appoint.
because
And there's central organization by the Supreme Court, then that has been deferred, sent to a larger bench, referred. Then there are two by Justice Nariman and Justice Bhatt, two decisions, the one of which invokes 142. That issue is no longer there. Yes.
My lord, instead of 10 claims, 12 claims are there.
Sorry?
Instead of 10 claims, actually it is 12 claims.
Yes, wherever I have said 10 claims, it will be 12 claims.
But
I will have to refer to this. Just one paragraph, I will put it in. Where I've appointed just before that, please. The decision of the Supreme Court in NTPC Limited versus SPML Infra 2023 9 SCC 385 was based on widening widening the domain of the arbitrator in keeping all considerations open for decision, including that of non-arbitrability. Stop.
blood.
Item number 9, WPA 3 of 2024.
So this is the order passed in an identical matter on which
Identical matter?
which was listed before the Honorable Court number 2, and directing the authorities to file opposition, some interim protection has been granted me. Because the demolition order is against 2 persons,
one is before this court in the present date application, the other one was before the court number 2, in the name of Nagmani.
1 minute. So who is the petitioner before this court?
Vijay Kumari.
No, that is who?
She is she is the one against whom the demolition has been directed, Your Worship. I think
And who is Nagmani?
she's both are sisters, Your Worship.
Sisters.
The two
So demolition against both.
both the buildings, Your Worship. Order entry is at page, Your Worship, 53 and 54. On various grounds, Your Worship, these orders have been challenged.
1 minute. So where is the order over here?
No, it's at page 53 and 54. Your Worship.
So it's a 26th December.
Yes, Lord, same.
Yes, Mr. Sivagalan, what did you say?
Yes, my lord, same order can be passed.
Yes, a learned counsel appearing for the petitioner places an order passed by a coordinate bench in on 6 February 2024 in WPA 82 of 2024, whereby the order which has been impugned in the present proceeding, comma, was stayed for a period of 4 weeks from the date of the order or until further orders, whichever was earlier. Stop. Council submits, next council submits that the same order, provisional order, to be provisional order, but the same provisional order, capitals, was served on the petitioner before this court, as well as the petitioner before the coordinate bench. Stop. Next, the respondents are represented. Stop. Next, on perusing the order placed before the court, order of the coordinate bench, comma, it appears that the learned judge found that the provisional order of demolition dated 26th September 2023,
December.
26th December 2023, within brackets, the same order applies here, close brackets, does not deal with the issue as to whether the sanctioned building plan will be the same plan.
Same plan.
Number 962, dated 1991, is in respect of building number 1 only. Stop. The court hence found that the impugned provisional order, insofar as it relates to the building number 2, this is also building number 2.
Building number 3, Lordship.
Insofar as it relates to the building number 2, in that case, which was claimed to be an occupation of the writ petitioner before the court, should hence remain stayed. Stop. Next. The same, the identical facts are before the court in this writ petition. The The only difference is that instead of building number 2, it should be building number 3.
Yes.
Stop. Learned counsel appearing for the respondents also admits that the same facts would apply. The same facts before the coordinate bench would also apply to this present writ petition. Stop. Next, hence, comma. There shall be an interim order in the interim order in favor of the petitioner. Now, hence, comma, the petitioner before this court is also entitled to the same relief. Stop. The impugned provisional order dated 26/12/2023, provisional order number 6247. 6247 dated 26/12/2023 shall remain in state for 4 weeks from today or until further orders, whichever is earlier. Stop. Affidavit in opposition within 2 weeks from date, reply within a week thereafter. Let the matter be listed immediately after expiry of the time for filing of affidavits. Stop. The affidavit service available, you are here.
I'm deep Blair.
Earlier, Blair, my lord.
But why should I keep both matters pending? Again, it will be before two different judges.
Both can be taken up, can I ask you, Lordship, that line can, Lordship.
Yes, since both the writ petitions contain identical issues, comma, let the writ petitions appear as connected matters before the next available circuit bench.
I'm grateful.
Right, my lord.
Item number 10, WPA 19 of 24. There was an appeal for the respondent, my lords.
First time.
First time. Yesterday it come.
No one appears for the petitioner.
So I have objections to the maintainability, my lord, that may be kept open.
Stop. Learned counsel appearing for the respondents submit that the issue of maintainability should be kept open. Stop. Next, let the issue of maintainability kept open as and when the matter is considered, taken up by the next available circuit bench.
My lords, I appear for 3, 4 and 6, my lords. 3, 4 and 6.
Learned counsel appearing for the respondent numbers 3, 4 and 6.
Right.
Stop.
Item number 11, WPA 93 of 24.
My lord, here the contract is selected, my lord, on 2nd February, my lord. So I intend to add the person who has been given the set contract, my lord. I have taken the complete detail of the set. So I want to arrange him as and I will service and let the matter appear in the next circuit, man.
Courier.
No, lord.
Courier as in the breed of a dog breed. What kind of security do you offer? Or does this?
It must be.
This manpower.
There's success to the perhaps the particular breed of dog. That's what I'm giving credit.
Yes,
I'm appearing only for respondent number 2, man.
yes, seeks to add the private respondent seeks to add the party which was given the contract on 2nd February 2024. Stop. Next, the particulars of the name and particulars of the successful bidder has been placed before the court. Stop. Next. the council is given leave to add quotation marks, Terrier Security and Detective Agency, close quotation marks, as a party respondent to the writ petition and make necessary changes to the cost title and other cost title, relief and other portions of the writ petition as found to be necessary. Stop. Copy of the amended writ petition shall be served on the respondents within, Mr. Kumar,
Within a week, my lord.
within a week from today. Stop, let the matter be listed before the next circuit bench.
My lord, on a lighter note, the choice of dog may be an additional ground which Mr. Kumar has.
Yes.
Item number 12. WPA 114 of 2024.
Should I appeal the petition in this matter? Service has not been effected yet though. It has been sent by speed post.
Yes, the learned counsel with the petitioner seeks an adjournment on the ground of service not being complete. Stop. Next, list this matter before the next circuit bench.
Declaration.
Number 13.
Malad, the mentioned matter, Malad.
2024.
I am for the petitioner, Malad.
This is the one which you mentioned.
Malad. Malad, I am working as accounts officer in Port Blair Municipal Council, Malad. Malad, kindly come to page 12, Malad. National.
1 minute, let me see it first.
Page 9 is the problem.
1 minute. Yes, so you said you want to join somewhere, but they're not letting you.
Malad.
Where do you want to join?
Malad, New Delhi, Malad.
New Delhi?
Page 12 is the advertisement, Malad. Published by the National Highways and Infrastructure Development Corporation Limited.
I can only see P1, page 12.
Yes, Malad. Serial number 15 is the post, Malad. Deputy Manager Finance. Now,
And
Malad,
how do I know this is New Delhi? Yes, New
it is
Delhi.
there, Malad, top. Corporate office.
And this is, what are you showing? What is this?
What is the advertisement, Malad?
Advertisement.
Published by the National Highways Infrastructure Development Corporation.
Where?
Malad, the date is there, top 14th/23 August 23.
Yes.
I applied for the post of Deputy Manager Finance, serial number 15.
Yes.
Malad, kindly come to,
And where are you now?
where I was selected.
Where are you working now? Before this?
Municipal Council.
Where? Yes.
Now, Malad, kindly come to page 21. The 16 to 20 is my application. The operative portion, page 21, dated 5th December 2023. And my qualification is MBA Finance, BCom MBA Finance.
Is this relevant to the court?
Malad,
Is this relevant?
yes, Malad, it is relevant.
Have you challenged your appointment?
No, go on, challenge. Malad, page 21.
Yes. What
It's
is
dated
what is
5th
this?
December 2023. This is the interview schedule for the post, Malad,
Yes.
in terms of the advertisement. Serial number 5 may be noted, Malad.
Yes.
No DATA or any other expenses incurred for attending interview shall be payable by MSCADL.
What is TADA?
Malad, traveling allowance and dearness allowance.
Yes.
I have to travel to Delhi on my own expenditure. Now, Malad, the provisional list was published by them. Page number 23, serial number 15 is my name. Serial number 15. K. Kumar, provisionally eligible for deputation, subject to submission of APAR, NOC and vigilance clearance.
Yes.
Now, Malad, kindly come to page 25, very important page, Malad, page 25. The respondent authorities, Malad, forwarded my application. It is dated 13 December 2023.
Yes.
Now, Malad, kindly come to page 31. The no objection certificate issued by the respondent authorities.
31.
3-1, yes, Malad. For applying for the post of Deputy Manager
manager finance and deputy manager finance. No objection certificate, my lord. Thereafter, page 32 is the vigilance clearance.
Yes.
Page 33 is vigilance certificate issued by the respondents.
So vigilance certificate was issued before the no objection.
Yes, madam. So, date is same, madam. I believe
Same.
13.
This is 13 December and that is 31st October. I was saying that is same.
No, my lord, signed by the administrative officer on 13/12. Vigilance certificate was issued by the anti-corruption bureau.
Yes, yes, vigilance clearance, I'm saying.
Yes, madam.
Yes.
Vigilance
Vigilance
of 30th October.
Yes.
Vigilance certificate issued by the respondents, my employer, page 33, on 13/12/23.
Yes.
Thereafter, my lord, integrity certificate, page 34.
What certificate?
Integrity certificate.
Yes.
My lord, page 35 is the request for 2 days casual leave and station leaving permission to appear before the interview board at New Delhi.
That is in December.
Yes,
So how are you interested now? Have you gone or not?
I've gone, I was selected. I'm coming to that. Page 36,
Back from the British history, please. Just come to relevant part.
my lord, then page 36.
Yes.
The appointment letter, my lord, issued by the corporation on 30 December 2023, copy to administrative officer. Bottom.
Yes.
I am running pillar to post, my lord. I am requesting them to relieve. They are not relieving me. Page 36.
So when did they get this? 30th December?
Yes, madam.
And when are you supposed to join?
My lord, they are given one chance. First page 40 may be seen, my lord. On my representation, they extended the time. Page 40,
Yes.
January 31st, 2024. Thereafter, my lord, I again approached them. They extended the time limit now up to February 2024. Last page, page
Up to
41.
February.
February 20. I received an email.
Yes.
At present, my lord,
What is it that you need?
madam, I should be relieved from the present post, then only I can.
No, what is it in the form of? The relief is in the form of a letter? What is it that you need?
They should relieve me from the post, not by giving a letter, by permitting me to join there. But at present, I am in pay band of 3. If suppose I will be allowed to join, I will get pay band of 10.
Please, I'm not here to decide whether it's going to be lucrative for you or not. Yes, yes, Mr.
My lord,
Chakravarti.
the writ was served just now, but my lords, I've been able to get one copy of this note, my lord. This is
Yes.
the departmental, this is on deputation, my lords. The post to which he wants to go is on deputation. My lords will find.
And reputation, but he is the PBRC here and he's got a job with the NHAI.
But his application is for 3 years on deputation basis. Those posts would have been advertised on deputation basis.
Yes.
One government's organization to another government organization.
Yes.
So my lords will see that NOC was given to him, but my lords, the department has said in the note that my lords, while giving the NOC also, it was clarified that final relieving order would be issued depending on the situation, whether the staff concerned, substitute staff, etc. are available or not.
Mr. Chakravarti,
The
do
next
it, do it, do it.
On the next page, my lords,
Yes.
it will, the department is saying that my lords, the 2 other, he is the only one who is working on permanent. The other 2 are temporary and they are supposed to, their periods are supposed to come to an end. And he's been working very efficiently, he has been an excellent person, my lord. So therefore, my lord, the department is saying that for the time being, my lords, it is difficult, my lords, for them to relieve him, my lords. Because,
How, very well. Not a question of, yes, what do you have to say?
my lord, I should be relieved, my lord, because it is a better placement. One suggestion, my lord, we can find.
We are saying the same thing ad nauseum, relieved. Anything else?
I'm praying for an interim order, my lord, in terms of prayer.
What is interim order? What is the final order? Tell me. Tell me.
I know, my lord, but time limit is there, my lord, that is the reason.
Time limit.
February I have to join.
Cutoff date
My lord,
is
if
20th
my lord
February.
is finally disposing it of my lords, when my lords, this note, my lords, this may be taken cognizance of, my lord. And if my lord is
So I would have to keep it on record anyway.
granting interim order, my lords, then my lords, I would request that it can be kept after, on the 19th, my lord, we'll file.
No, my lord. 20th is this last.
Because the final relief is the same, my lord. There is no question of.
There's no question of keeping it pending.
My lord.
The petitioner prays for a direction on the respondents, comma, more particularly, respondent numbers 1 and 4 being the Lieutenant Governor, comma, A and N Islands, and the Secretary, comma, Port Blair Municipal Council, comma, respectively. To relieve the petitioner, RELIEVE, relieve the petitioner from the petitioner's present assignment. Stop. Next, the reason for seeking this relief is this one, please. What did I say? Is that the petitioner successfully participated in a selection process, in a selection for the post of deputy manager within brackets finance. Against a vacancy in the National Highways and Infrastructure Development Corporation Limited. Stop. The post was advertised on 14/23/8/2023. And the petitioner went through the required levels for selection, for the final selection, including appearing for an interview in at New Delhi. Is that correct? Where was it? At New Delhi. Stop. The petitioner's provisional eligibility for deputation was communicated thereafter. Stop. Was communicated by NHAI thereafter. Was communicated thereafter by NHAI. Stop. The PBMC the PBMC / respondent number 4 took several steps in support of the petitioner's participation in the selection and also following the petitioner's provisional appointment. Stop. The petitioner's application was forwarded to the PBMC forwarded the petitioner's application to NHAI on 13/12/2023, issued a no objection certificate, capitals. On the same day, cleared vigilance requirements, gave vigilance clearance on 31/1/2023 and issued a vigilance certificate on 13/12/2023. Stop. The PBMC also issued an integrity certificate to the petitioner on 13/12, on the same day, i.e. 23. Stop. Next, the petitioner's grievance arises out of a series of letters given by NHAI from 30/12/2023 onwards, communicating that the petitioner had been selected, has been selected for the post of deputy manager within brackets finance on deputation in NHIDCL, and that the petitioner is expected to report for duty within 10 days from this letter, from the letter which was sent on 30/12/2023, from the date of the said letter, Stop. The petitioner, since the petitioner was not being relieved by the PBMC, by the respondents, the petitioner requested for extension of the petitioner's joining date, and such extensions were granted on 22/1/2024 and 30/1/2024. Stop. Next, the petitioner is now scheduled to join the post latest by 20/2/2024, 20th February. Stop. Next, learned counsel opening for the respondents. Hands up. What is this criminal corruption case against K. Kumar? What is this?
It says there is no, they have said there are no cases pending.
Hands up for note, capital N, note, which states, inter alia, that the petitioner is well versed with the service and accounts rules and what does it say? That if he goes, it will be
Yes,
difficult?
my lord, on the second page, my lord, it says that
And that there are 2 accounts officers who may be repatriated to their parent department on or before 6/4/2024 / 4/8/2024. Stop. Council submits that the petitioner is an efficient worker and his absence and his leaving the department and his leaving the PBMC will be against the PBMC's interest. Stop. Next, upon perusing the note, capital N, handed up by on behalf of the respondents, the court is of the view that the petitioner cannot be kept, cannot be restrained from joining his new assignment with the National Highway, NHIDCL, whatever that is, I've said that before. Particularly when the petitioner has successfully participated in the selection process and has undergone, particularly when the petitioner has particularly when the petitioner has been selected against a sanctioned post, stop the respondents' apostrophe resistance to relieve the petitioner cannot be understood in light of the several certificates, capital C, issued by the respondent PBMC to the petitioner in support of the petitioner joining the new post. Stop. The petitioner has already been given 2 extensions for joining the new post, and the excuse that the PBMC does not have other efficient officers to fill up for the petitioner is unacceptable at all levels. Stop. Next, in any event, comma, the note is unclear to that extent and does not spell out any specific reason for the respondent's reluctance to act in terms of the petitioner's letter of appointment and the date of joining, comma, in particular. Stop. Next, considering the material on record, particularly the series of certificates issued by the PBMC to the petitioner and the petitioners and the extensions given to the petitioner to join the new assignment, latest by, what is that date?
20th February.
2024, WPA 125 of 2024 is allowed in this post of by directing the respondents to relieve the petitioner. If I say forthwith, then how will that help you?
Within a week, Mela.
Your prayer says forthwith. Forthwith can also be 21st February. Within 7 days from today, so that the petitioner is able to join the new post by 2024. Stop. The respondents shall extend all assistance for due implementation of this direction. Stop. All assistance to the petitioner for due implementation of this direction.
I'm deeply obliged, Mela.
Number 40. WPS 680.
I am appearing for the petition.
Yes, sir. Kumar, I should keep it on the next yes. List this matter in the next circuit bench as proof for on behalf of the petitioner.
Joint, no, let it behalf of the petitioner, man. We have, it's no difficult.
Why are you opposing joint?
This is
prayer?
my lord joint, no, this case, my lord joint prayer, yes. Yes. Let it be a joint.
Is there a catch to it, Mr. Kumar?
No, madam.
No.
Actually, my lord, this matter is pending from a court time. So tomorrow they will take a
Good, but
stand
they
that I
say
have
we are
sought for
taking-
time.
As paid for on behalf of the parties.
My
My lord.
Any other matters which you want to do?
No.
Why are you saying no, Mr. Chakraborty?
I'm respondent, my lords, I'm ready, my lords, if the petitioners want to do, my lords.